Hashtag how class action lawsuits work. Hook in 1994, a woman sued McDonald's over a cup of hot coffee and won nearly $3 million. Most people laughed at that case. Late-night hosts mocked it. Entire television segments were dedicated to ridiculing it as the ultimate example of frivolous American litigation. But here is the part nobody told you: that woman suffered third-degree burns across 6% of her body, required skin grafts, and McDonald's had received over 700 prior complaints about the exact same issue. The joke was on us for believing the spin. Tease in the next 10 minutes, you are going to understand exactly how class action lawsuits actually function, from the moment someone realizes they have been wronged, all the way to the final settlement check. You will learn why most people receive shockingly small payouts, why the lawyers always seem to do better than the plaintiffs, and the one structural feature of class actions that makes them simultaneously the most powerful and most criticized legal tool in American history. Stay with us, because the answer is genuinely counterintuitive. Background: class action lawsuits did not appear overnight. Their roots stretch back centuries, to English equity courts in the 1600s, where judges recognized that sometimes one representative could stand in for many people with identical grievances. The logic was simple and elegant: why clog the courts with 10,000 identical cases when one carefully managed proceeding could resolve them all simultaneously? In the United States, the modern class action was formalized through Rule 23 of the Federal Rules of Civil Procedure, first adopted in 1938 and significantly revised in 1966. That 1966 revision is the real turning point in American legal history. It dramatically expanded the scope of who could bring a class action and under what circumstances, and it transformed the mechanism from a procedural convenience into a genuine weapon for social and economic accountability. The civil rights era supercharged their use. Suddenly, class actions were being deployed to desegregate schools, challenge discriminatory hiring practices, and hold government agencies accountable for systematic violations of constitutional rights. By the 1970s and 1980s, plaintiffs' attorneys had discovered that class actions could also be enormously profitable in the consumer and product liability space. Tobacco companies, pharmaceutical manufacturers, and financial institutions all found themselves facing consolidated legal challenges of unprecedented scale. Main content: so how does a class action actually begin? It starts with a single person, called the named plaintiff or lead plaintiff, who believes they have been harmed by a defendant's conduct. That person hires an attorney, who then investigates whether the harm is widespread and whether others share an identical or substantially similar legal claim. This is the foundational question: are you dealing with an individual problem, or a systemic one? For a lawsuit to proceed as a class action, a federal court must grant what is called class certification. This is not automatic, and it is not easy. Under Rule 23, the plaintiff's legal team must demonstrate 4 core requirements. First, numerosity: there must be enough affected people that joining them all individually would be impractical. Courts generally look for at least 40 members, though cases often involve millions. Second, commonality: the class members must share common legal questions or facts. Third, typicality: the lead plaintiff's claims must be typical of the broader class. Fourth, adequacy: the lead plaintiff and their attorneys must be capable of fairly representing the entire group. Beyond those 4 requirements, the case must also fit into one of 3 categories defined by Rule 23(b). The most common in consumer cases is Rule 23(b)(3), which requires that common questions predominate over individual ones, and that a class action is the superior method for resolving the dispute. This is where many class actions fail at the certification stage. Defendants frequently argue that individual issues are too distinct to be resolved collectively. Here is what most people do not realize: class certification is often the most bitterly contested phase of the entire lawsuit. Defendants spend enormous resources fighting it, because a certified class transforms the legal and financial stakes dramatically. A defendant facing one lawsuit for $10,000 has little incentive to settle. That same defendant facing a certified class of 5 million consumers, suddenly the math looks very different. Once a class is certified, notice must be sent to all potential class members. This is often done through mail, email, or published advertisements. Class members typically have the option to opt out, meaning they can exclude themselves from the class and pursue their own individual claims instead. Most people do not opt out. Many people do not even open the notice. And here is where the numbers get interesting. Studies consistently show that in consumer class actions, individual class members receive an average payout somewhere between $5 and $30. Some settlements produce checks for less than $1. Meanwhile, the attorneys representing the class routinely receive fees amounting to 25 to 33% of the total settlement fund, sometimes hundreds of millions of dollars. In the 2012 settlement over price fixing in the LCD flat panel industry, class members received checks averaging around $25. The plaintiff's attorneys received over $400 million in fees. Is that fair? That depends entirely on how you think about the purpose of the mechanism. Deep dive, because here is the deeper truth about class actions that nobody in mainstream media explains properly. The primary function of a class action is not to enrich individual plaintiffs. It is to deter corporate misconduct at scale. Consider the economics of wrongdoing. If a financial company overcharges 5 million customers by $3 each, that is $15 million in wrongful profit. No individual customer has enough incentive to hire a lawyer and sue over $3. Without a class action mechanism, that company keeps $15 million and faces zero accountability. With a class action, that conduct becomes economically catastrophic for the defendant. The deterrence effect is the whole point. This also explains why defendants fight class certification so aggressively. Disaggregation, breaking a class apart into individual claims, is a corporate defense strategy as much as it is a legal argument. The moment a class is denied certification, most plaintiffs disappear. The math simply does not support individual litigation for small dollar harms. There is another layer here that legal scholars debate intensely: the Cypress doctrine. When settlement funds go unclaimed, because class members cannot be located, or simply do not cash their checks, courts must decide what to do with the money. Under Cypress, those residual funds are often distributed to charitable organizations or legal aid foundations rather than reverting to the defendant. Critics argue this arrangement reduces defendants' incentive to actually locate and compensate class members. Proponents argue it is the only practical solution to an inherently imperfect system. Now consider some landmark examples. The 1998 Tobacco Master Settlement Agreement, technically not a class action but often compared to one, resulted in tobacco companies agreeing to pay over $200 billion to state governments over 25 years. The 2013 settlement over defective Toyota accelerators reached approximately $1 billion. The Wells Fargo unauthorized accounts scandal produced a $142 million settlement for approximately 3.5 million customers. These numbers sound enormous until you divide them by the number of people harmed. Analysis: what does all of this mean in practical terms for ordinary people? If you ever receive a class action notice in your mail or email, pay attention to it. Read the settlement terms. Understand whether opting out makes sense given your specific circumstances, especially if you suffered significant individual harm that exceeds the average class recovery. Consult an attorney before deciding. Many people reflexively ignore these notices and forfeit whatever small recovery they are entitled to. For society more broadly, class actions represent a genuine tension at the heart of American legal philosophy. They are simultaneously a mechanism for justice and a generator of perverse incentives. Attorneys are motivated to bring cases, which is good, but also motivated to settle quickly for amounts that maximize fees rather than plaintiff recovery, which is bad. Courts have increasingly scrutinized settlement terms precisely because of this misalignment.